I'd like to thank the organizers for this inviting me to make this presentation. I'm actually substituting Dean Fanelli, and he's not well and he's not in here. He would have actually given the US perspective, but since I don't know the US perspective and I can't speak about that, I've been asked to give about the India perspective. I know I looked at the earlier session that happened more on India Pharma, so I'm giving something little different, which I can talk about. And I was only looking at the pharma issues post-Gleevec, which is a very important case law in India on imatinib mesylate. What's my agenda? I'm going to talk about the Supreme Court ruling in the Novartis versus the Union of India. I'm going to talk about Section 3D, Section 3E and 3I, and implications for applicants. So let's, do I get 10 minutes, moderator, Rana? 10 minutes or how much time?
About 20, 25 minutes.
No, I don't think we have so much time. We have? I'll try to finish in 10 minutes and we leave it for more question and answers.
You were supposed to end at 6, but since you begin at 4:30, actually, we can
Okay.
at 6:30. So
Okay.
it's 20 minutes, a little over 20 minutes for each.
Yeah. So what are the important observations of the Supreme Court? We have a section which is Section 3D, which is directed to chemical substances, particularly pharmaceutical substances, and it is an additional requirement to the inventive step requirement. And in Novartis, it raised an argument that a compound having an inventive step will ipso facto cross the Section 3D. However, the court rejected this argument, stating that if enhanced efficacy is not proved, Section 3D cannot be overcome, even if the invention may otherwise possess inventive step. So this is a step one above inventive step, that you need to pass this hurdle as well, which is Section 3D. What are the observations of the Supreme Court? What is this known substance, and what is this bar that we have? How do we get over that thing about Section 3D? They really need to know what is a known substance. I know Rahul Vartak did talk about it, and so I'm just going to run through some of the slides which may be repetitive. Novartis has consistently claimed before the US FDA and even before the UK courts that imatinib mesylate was covered within the claim scope of its earlier umbrella patent. However, in India, Novartis argued that only imatinib and not imatinib mesylate was enabled in the earlier umbrella patent for skilled person, and the argument was rejected by the Supreme Court on the facts, and Supreme Court referred to the specification and the subsequent conduct of Novartis. This is just limited to the facts. They're not talking about everything on Section 3D. This was only with imatinib mesylate, the polymorph, the beta form of imatinib mesylate, and that was why it is very specific and limited to the facts of the case, and it just cannot say that it is across 3D. So this is what Supreme Court said. It will be a grave mistake to read this judgment and to mean that Section 3D was amended with an intent to undo the fundamental change brought about in the patent regime by deletion of Section 5 of the Indian Patent Act. I'm sorry, there's a mistake here. Limited to fact, it should be Patents Act, I don't know. Limited to the facts, we've held that the subject product does not qualify the test of Section 3D of the Act, but that is not to say that Section 3D bars patent protection for all incremental inventions of chemical and pharmaceutical substances. What are the other observations of the Supreme Court? For a chemical substance that has to get past Section 3D, you need to show efficacy, and they mean efficacy to mean therapeutic efficacy. And so it's really basically with the pharma that this whole thing came about. And in view of the object and purpose of efficacy, it is to be interpreted strictly and narrowly within this sense. That is, you just cannot now go further. It should be very narrow and restrictive. Now, they refuse to accept or reject the following argument by Professor Bashir. who's also responsible for spicy IP. I'm sure many people read that. He argued that safety or significantly reduced toxicity should also be taken into consideration. They didn't talk about it because in imatinib mesylate, there was this question of reduced toxicity did not come up. Mere improvement in physical properties will be insufficient to overcome Section 3D, which would happen in all other countries, but not in India. And there was no general ruling on a link between bioavailability and therapeutic efficacy. And the position that emerges is that increased bioavailability alone may not be necessarily lead to an enhancement of therapeutic efficacy, and it must be specifically claimed and established by research data. So if you don't have that data in your specification, you can always give an affidavit, a declaration, and show that this has got enhanced efficacy. However, we need to know the known substance. Only if you know the known substance can you show enhanced efficacy over the known substance, and this is what we've been telling the patent office, that it is very important that they come out in their examination reports to show what is that known substance. Now, this ruling of the Supreme Court was limited to facts, and the court held that Novartis had not filed evidence that a 30% increase in bioavailability would result in enhanced therapeutic efficacy. I now go to Section 3D just to see now what is this Section 3D. It has really come from the EPC regulatory approvals, and there it is other derivatives. So if you have an active ingredient and it has been approved, so if you don't come now with another derivative, then you need to show that it is not the same substance, it's a different derivative, it's a different molecule altogether, and that's why it will go through the regulatory approval. Now, the government of India did take this explanation to the Section 3D and put it in from the EPC regulation and put it as an explanation into Section 3D. So here it says the mere discovery of a new form of a known substance which does not result in enhancement of a known efficacy of that substance will not pass through the Section 3D. A mere discovery of a new property or new use of a known substance will also not be allowed under Section 3D. I don't go into processes because it's out of this. I don't want to talk about this. But what really Section 3D says is, for the purposes of this of Section 3D to interpret it, salts, esters, ethers, polymorphs, metabolites, particle sizes are all considered as the same substance. But most important, they said combinations and other derivatives of known substance shall be considered to be the same substance unless they differ significantly in properties with regard to efficacy. What we want to tell the Government of India and the IPO, that known substance should actually be the active ingredient, and that it is a derivative of the active ingredient. But they are not listening. I think Justice Prabhadevan has done a good job in a couple of cases to show that you have to show what is a known substance, and without that you cannot. Even the rejection yesterday by the patent office on one of Gilead cases, there's just a statement saying they rejected under Section 3D, and this is, even though it has passed the test of novelty and inventive step, you can get rejections under Section 3D. So let's look at what are the principles underlining Section 3D. So you need to seek clarity, you need to have support, and the question is, what data do I need to give? Now, Patent Office considers, you need to really, they say that you have to have increased enhanced efficacy, and are they looking at toxicity data to be a relevant evidence against and show that it is increased efficacy? They're not, because the present pre-grant opposition that was rejected by the patent was rejected by the patent application was rejected by the controller just based on that they did not have enhanced efficacy. They did have enhanced efficacy, reduced toxicity, but he refused to accept it. I just want to talk about this. What do I mean by clarity? What is that known substance? How is it a derivative of that known substance? And what is the basis to assert same efficacy? So for this, what is the support you need? You need to have at least some assertion in the specification. You can give data, and it can be produced later, and it can be considered. What type of data do you need? Do you need animal studies? The Supreme Court has said that you need therapeutic efficacy, but you can say that it can be animal studies, comparative data with the known substance, and Supreme Court did not exclude bioavailability in all cases. And therefore, bioavailability can be a test as long as it gives enhanced efficacy. Already people have talked about the GSK decision on the IPAB in 2013, which emphasizes on the burden of proof on the challenger. So anyone opposing a patent, or if you have a pre-grant opposition, they have to clearly show what is the known substance and how does the compounds in the present application being a derivative or a new form of that known substance. So it is really on the burden is on the challenger. But the patent office really doesn't seem to get affected, and they will not go so much into this. They just give one line that this patent, this application, or the claims of this are objected under Section 3D. Now the position that emerges is that just increased bioavailability alone